Revisiting the Fundamentals of Jurisprudence and Its Significance by Mr. Sourabh Vasant Chhaya Ubale, Assistant Professor of Law, Marathwada Mitra Mandal Shankarrao Chavan Law College, Pune, at Government Law College, Villupuram. Government Law College, Villupuram, Tamil Nadu, under the guidance and supervision of its Directorate of Legal Studies, Tamil Nadu, and affiliated to the Tamil Nadu Dr. Ambedkar Law University. It is a dynamic institution that promotes access to justice by imparting quality legal education with value boundedness and public spirit in the students. I would like to take this opportunity to welcome our principal madam, Professor Dr. N. Kayalvili, to welcome the speaker and the attenders and give introduction about the topic. It's my honor to give introduction about our principal. Principal Madam has about 25 years of academic and administrative experience. She has published about 13 articles and holds membership in various professional bodies, which includes expert committee member to Tamil Nadu State Council for Higher Education, website coordinator of the Directorate of Legal Studies. Her specialization and area of interest are international law, constitutional law, environmental law, research methodology, and information technology. Madam has organized diversified programs, seminars, national and international online events, round table conferences, special lectures, etc. She motivates legal fraternity to excel in participating moot competitions, to publish papers, to do research, to be a scholar guide. It's our pleasure to have as our principal. Over to you, ma'am.
Thank you, Jennifer. Esteemed guest for today's special lecture, Mr. Sourabh Ubale, the faculty of Marathwada University of School of Law, esteemed faculties, my dear students, a warm good morning to one and all present here. It gives me great pleasure to conduct the special lecture on the topic jurisprudence. The reason being, jurisprudence is the eyes of law in human body, as our eyes are one of the most essential part. Most of our activities that we do it with that specific organ. Unless a man can see anything correctly, he cannot do any work properly. Therefore, jurisprudence is called the eye of law because jurisprudence functions for law like an eye for a human being. This jurisprudence helps you not only to learn the intricacies of, say, the right or wrong, what is the correlative duty that you have, how you are supposed to approach the term law in the connotation, say, of constitutional law, or in the connotation, say, of international law, or a property law, or a contracts. This jurisprudence gives the fundamental basis of all laws, and therefore we thought it's pertinent that we need to revisit the subject jurisprudence, and therefore this special lecture was organized to you. The core function of jurisprudence is to study the origin of law. You, by studying jurisprudence and couple other subjects, say interpretation of statutes, General Clauses Act, and throwing oneself, say, in Constitution Act of India, would help you to understand the term law at length and breadth. And not only that, this will help you even in practicing point of view in order to go in depth to any of the specific legislations or general legislations that you approach. And therefore, we thought it's essential that you need to be given more learning on this subject, not only from your faculties, but distinct faculties of law who belong to various colleges of India. And therefore, I thought the most deserving and person and the most intelligent of all that I've seen, the millennial generation, is Sourabh Ubale, and you will definitely acknowledge my words. And therefore, please kindly pay attention to whatever he's got to say today and learn from it. Thank you. I deem it a pleasure to welcome Sourabh Ubale for this virtual special lecture series of Government Law College, Villupuram. Thank you. And I also feel happy to invite all my dear faculties to be part of this gathering. I also welcome all my dear students and advocates who are listening to this lecture. Thank you. Jennifer?
Thank you, ma'am. Thank you for your welcome address and your importance of this today's topic. Now, may I invite Miss G. Suganya, first LLM, to give intro about our special lecturer of the day. Over to you, Miss Suganya.
Thank you, Jennifer. Good morning to one and all present. On behalf of our Government Law College, Villupuram, I welcome our special lecturer, Sri Sourabh Vasant Chhaya Ubale, who is the Assistant Professor of Law in Marathwada Mitra Mandal, Shankarrao Chavan Law College, Pune, affiliated to Savitribai Phule Pune University, accredited by NAC with A grade. Sir has pursued Bachelor of Social Legal Science, Bachelor of Law, and Masters in International Law in Savitribai Phule Pune University. He pursued his postgraduate diploma in human rights. He is pursuing his Master of Arts in Public Administration in Indira Gandhi National Open University. He is qualified in CBSE UGC NET December 2015 for Assistant Professor and qualified for the Junior Research Fellowship. Sir has pursued his doctorate in law in the Department of Law, University of Mumbai. Sir has 1 year experience in practice and 6 years experience in teaching. He has done several researches which are law and policy standard in transforming Indian school education, right to food as a basic human right in India, right of children to free and compulsory education, human right issue regarding tribal people in the country, human right issues and state of Maharashtra, climate change and human right violation of right to food, global food crisis and impact on right to food, food and agricultural organization, maritime trot, transforming employment sector into green jobs. Sir has presented 11 papers including international, national and state level in various streams. He is a resource person, delivered guest lectures and guided 17 dissertations so far. His areas of interest in law are jurisprudence, international law, environment and climate change laws, human rights, research methodology, science and technology related laws. Sir has secured second rank in India and won a special Rio Plus 20 silver medal in Rio Plus 20 India Program of Sustainable Development 2013. His contribution in international national program is tremendous. He is a man of hard work, intelligence and generosity. He has published 5 journals and 2 chapters in books. At present, he is a member in LLM Syllabus Committee Members Department of Law. He is working towards connecting youth minds to strive towards success and achievement. We are grateful to him for accepting our invitation and becoming our special lecturer of today's special lecture. We are so honored to have him as a special lecturer. Once again, welcome you, sir.
Thank you, Ms. Suganya, for your elaborate introduction. Now, platform is yours, sir. Over to you, sir.
Yes. Thank you so much, everyone, students, and a special thanks to your beloved principal and the most, no, we say, the most close person to my heart is the Kyle Didi. So Kyle ma'am, which is who's your principal. So we're fortunate to have a principal like her. And I mean, it's kind of an envy that we have because no, we know that as the person is not only a person who is of the intellectual, high intellect that she is having, but no, a generous person at her heart as well. Okay, thank you so much, ma'am, for inviting me to this particular special guest lecture. I just request that can I share my PPT because here present now option is not available. I just want to share my PPT.
Yes, sir, we'll give permission to you, sir.
Yes, sure.
Yes, sir, it has
Yes,
given.
yes. Hope it's visible. Uh, is it visible to you?
Yes, sir, it's visible, sir. It's
Yes,
visible.
great. Yes, great. Okay, so let us go ahead in the topic revisiting the fundamentals of the jurisprudence and its significance. Now, when you utter the word jurisprudence, it probably gives you a kind of a different feeling than the rest of the subjects. Okay, so when I used to read different kind of letters and the messages from the students, and I usually get the messages that this is a boring subject and why we have to study such kind of subject, what is the importance of this particular subject. And no, basically what we need to have is some kind of an approach why we have to study this particular subject. Then we also have to build up the approach how we have to study this particular subject and what exactly we are going to study in this particular subject. So all these three dimensions are important when we talk about the jurisprudence as a subject. Okay. Now, when we have the jurisprudence, these are the things that we usually study in our jurisprudence paper. So basically, when we talk about the fundamentals, then basically these are the three important fundamentals we can consider as the general aspect. Another is the theories of law. One is the source of law, and the last is the jural concepts or legal concepts that we have in the jurisprudence. So basically, I'm not going into details of it because this is a part of your whole syllabus of the jurisprudence that you learn in your schools, law schools. And so, no, this is just kind of an overview of what exactly includes in the jurisprudence. So when we have general aspects, we know that the role and the purpose of the jurisprudence, the definition part, the different kind of the legal theories, the introduction of the legal theories that we have to study in this. Okay, the very first part that we have to study in the jurisprudence is the legal theories. Okay, so you have different kind of schools, different kind of theories, and you try to understand those kind of theories, how and why that particular jurist have said this particular thing, and what is the use of this particular thing in modern context. Okay, so all that you study when you try to understand the schools of the jurisprudence. When we try to understand the sources, you come to know that it is not just the origin of the law or the principle, but it gives you an idea that in what context and what are the things that are useful or can be taken into consideration at the time when we have the application of law in the practice. Okay, and the last and the foremost important point that you study in the jurisprudence is the jural or legal concepts. Okay, so basically rights and duties, person or personality, ownership and possession, property, liability, title. So you have n number of the concepts, or we say it as a legal concept, which we come across in our day-to-day transaction of our life, as well as a legal, we can say, relationship amongst ourselves or with you as a lawyer to the judge. Okay, and so in all this context, we use these kind of the words, and that's why it is important to study the jurisprudence. Okay, so this is an overview. Let us talk about the questions that have been posed or that have been asked by the students. So they usually ask, what is the wrong with the jurisprudence? Is the jurisprudence worth studying, or is the jurisprudence necessary to study? So why one shall study the jurisprudence? So these are the questions that as a faculty, as a researcher, as a student of jurisprudence, I think that I shall give in some different contexts, okay? General significance that you already have studied into your law books, okay? But what exactly beyond that text of the law, we also have to think of it, okay? And so that's why we need to give the answers to these particular questions. So how we can give these answers to this particular question? So I have bifurcated it in two ways: giving answer from simple to complex, and then complex to simple. Okay, so let us try to understand what the jurisprudence does when it comes to the studies that you have. Okay, because see, when you have the Transfer of Property Act, when you have the procedural laws, when you have the Indian Contract Act, all the laws now they are such of such nature that you know that after completion of your law degree, or after understanding that particular law as a subject, you are going to have its application. But then why it does not happen with the jurisprudence? Because it is something where students are the thinkers who think. I mean, the thinkers, I always say to those who think that the jurisprudence is not a good subject, or it is boring subject. Okay, and so for those also, their approach we need to have, we need to change. And so how to change the approach? By understanding and by building up some kind of, we can say, tactics to deal with this particular subject in a modern context. Okay, so I'll pose you some questions after some slides that have been discussed. Then probably you'll come to know that how the jurisprudence works. Okay, so before that, let's try to understand in a simple to complex way that how or what is the significance of the jurisprudence. Okay, what are the fundamentals in understanding the jurisprudence? The very first is understanding the nature of law, or what is law. If I say, okay, you cannot do XYZ thing because law is not permitting you to do that particular thing. When I say so, then what is exactly the nature of law? Why I cannot do any particular act which is contrary to what is asked from the government or by the government, or what I cannot do any particular act which is not been accepted by the people at large. So again, a different kind of perspective. Why I cannot do any particular act if the judges have said so. Okay, so again, a third kind of an approach. So if you understand the baseline of all these three statements, you'll find it out in a very first case. I tend to talk about the positive law, the law given by the sovereign authority. So I have to follow, because the given law by sovereign authority saying that if you do not follow, we will punish you. Going ahead, in a second case, if I say the society don't want me to behave in such a manner, it means that the social pressure is there. Okay, there are some group which are very much active when it comes to the community. And so probably, is that going to have any impact on considering any situation as law, is one of the questions. That is the second part. And the third statement that I have made regarding the judicial pronouncements. Okay, so I shall not act contrary to what the judges have said. Why it is so? Because we consider them as an authority. But we know that though we consider them as an authority, but only some part of the judgment we can follow. That's why the concept of ratio decidendi and obiter dicta has come up. So this is how to understand the nature of law, or what is law. You need to understand the jurisprudence. You need to understand the different theories of the law. Secondly, it traces down, or it tracing the underlying principles of law. So for example, as I said, you cannot do the contrary. Okay, you cannot go against what is intended by the legislator. When I say so, it means that some principle must be underlying behind that particular statement. Okay, so to trace out that particular principle, you have to check it out with the jurisprudence, that how the jurisprudence asks us, or how it elaborates different kind of principles. Okay, So it is not always like you have law of torts. Okay, we know that the tortious law, that law of tort, is something where it gives you a kind of a principle and the justification for that principle why we have to follow. So basically, answering the question why is tracing the underlying principles of law. The third is develop a wider understanding of the nature and the working of law. So we know that what is law, why it is the law, but we also have to understand how the law works in the society. Consider that some particular element has been passed, some law has been passed by the higher authority. Unless we have its implementation, probably we would not come to know that how or what are the loopholes in that particular law. And this happens only when you study the jurisprudence. A simple example, when you say, okay, the recent example regarding the agricultural laws been given by the central government, okay. So when you have such kind of laws, when you put into motion, then only you will come to know that how it works, what are the loopholes, and what is the connection of the jurisprudence into this? No, again, it's a conflict between the positive law and the sociological jurisprudence. Positivist jurisprudence, sociological jurisprudence. When the matter will go to the court of law, then again one more theory will be added to the conflict, and that is the realist school of the jurisprudence, realist theory. So after the analysis of all those contexts of the farmer's law in connection with the jurisprudence, you will get the better understanding, and not only the better understanding, the better justice. Okay, we usually say that we cannot have the 100% justice. Why we say so? Only because there are some loopholes either in the facts or in the law. Okay, so those loopholes we have to fulfill. We have to fill the gaps between those provisions, and then we can have a better understanding and better solution to that particular problem. The fourth important element is the interdisciplinary. What is interdisciplinary? Is that where you try to attach too many disciplines with the law when it comes to the jurisprudence. Okay, like psychological theories. Okay, so when you understand the psychology, the jurisprudential angle, you will probably come to have more better argument when the criminal case is pending in the court of law. Okay, so this is how you correlate. Or for example, economic matters. So consider that some financial fraud has happened. So when you have understanding of economic along with the jurisprudential perspective, then you can come up with the conclusion that in this perspective we can have the understanding of it. Okay, the simple example I can give in context with the realism. What we study in the realism, we study the law given by the judges. Okay, we study the judge-made laws. So though in the Indian context we shall not say judge-made laws because judges are allowed to interpret the law, but when you have the realist concept, probably in an interdisciplinary may have its impact on such kind of cases. Because see, in the realism we study that how the judges been backed by their personality, by their upbringing, and that is on the okay. So if your case is in the court where the judge is very well versed with the economic crimes and the financial frauds, then probably the decision may be something different as compared to the decision given by the judge when the judge is not having much understanding of the financial crimes. And we know that it's a human being, okay, so we cannot have the knowledge of each and everything which happens in the world, okay, and so that's why we need to understand the jurisprudence in that context. The fifth is that the justification or basis for the judicial decision. Okay, we know some of you might have come, might be a judge or in the court. Okay, and so you know that it's just not declaration of the right is important. Okay, so when you want to give a judgment, it means that the judgment, that decision must have the justification. If you read any particular case, a specific relief act, and you just have said that, okay, this is a breach of contract and this is a specific performance that the party has to do. But why? And that why you have to provide into the decision, into your judgment. And that justification, that base of the judicial decision lies with the understanding of the nature of law, with the understanding of the jurisprudence. Okay. So that is the most important thing. Then it comes to the realities. Okay, why the realities? We know that we still have the laws now which are older as compared to the modern era. Okay, but it does not mean, I mean, no, you must have heard that okay, this is the oldest law and we shall need to have a new law, no, repealing the previous law. But is it needed? Do we need such kind of things? If necessary, then ultimately we are going to do that. Okay, but it is not just that it is an old law and so that's why we have to come up with a new law. Okay, it shall not be in such manner. And so that's why the legal no, the realities plays an important role in this concern. And now I'm going to discuss it with the legal sphere and social knowledge, because when it comes to the reality, we know that we need to have the social knowledge. Okay, we need to understand what is the strata of the society. The reservation policies in, say, for example, Canada or in France may not be similar with the reservation policies in India, or India cannot adopt the laws regarding the financial fraud as they are there in the Singapore or they are there in the in United States. Why? Because the social, economic, political conditions, they differ. And this understanding you come to know when you analyze the law, when you understand the nature of law jurisprudence. Then the eighth important point is that making of the legislation. So law ought to be, because no, we make the law, what it means, how the law should be, the ideal situation of law. Law ought to be the, okay, it is not what law is, but law ought to be. What it means, it is not what we are applying to the current situation, but we also have to think from a future perspective of application of law, because once we make the law, once the legislation is there, okay, we cannot have the daily changes in the legislation. Okay, we have to have the flexibility as well as rigidity, both the things shall be there. And so that's why when you understand the jurisprudence, when you understand the theoretical base of the law, then you will probably come to this law ought to be idea, and then you can implement it, incorporate those principles while framing the law. The ninth important element is that it sharpens the lawyer's ability to think logically. We know when you are in the court, whatever the laws that you have read, okay, so you just have an application of law and you can put forth your argument. Okay, but if you have the better understanding of the right, okay, for example, if I say what is your right, okay, so you must have a better understanding that a right must be associated with the duty. Okay, so what kind of duty, what is moral duty, or what is legal duty, what is moral right, what is legal right. So all that things, if you know, then you can have a better or logical argument you can put forth, because ultimately judge is not going to have just closing his eyes and just not applying the law and going to give the decision. He's going to hear you, your opposite party, and then by analyzing the legal principles, by analyzing your arguments, he is going to give the decision. And so to sharpen the ability to think logically, the lawyers must understand the nature of the law and the principles laying behind that. Okay. Then you have the comparative studies can be carried out. Okay, what is comparative studies? For example, say when you have any particular application, or consider the Roscoe-Pound's theory of social engineering. Okay, now what he said that we have to bifurcate the interest of the individual into three categories, and then we have to correlate it. We have to adjust those interests so that we cannot have the chaos in the society. Now, when we have so, this particular, when we apply, we can have its application in Indian context. We can also have its application in, say, Nepalese constitution, or Nepalese in Nepal. We also have this particular aspect in the European countries. And all the time, when you put that particular formula depending upon the legal systems, you get the different answers. And not only the answers, but the ways how the people and the system thinks about the jurisprudence and the legal principles and the law. Okay, so probably that's why we can say that considering the LGBTQA plus rights in India is so far lacking behind as compared to some of the nations like the European countries. they have. Okay, why it is so? Because after understanding, after having the comparative studies, you will probably come to conclusion that how we can have this particular approach in dealing with the matters of the prime concern. Same happens with the prostitution. Prostitution, whether legal or illegal, okay, we are still in a question, okay, and in both of the aspects we have our justifications, though it may be legal or moral, but still we have the justification, and so that particular aspect is still unanswered. Okay, then it comes to the gaps, loopholes, or ambiguities, borderline cases. So in all these contexts, if you find it in the law, in the legal framework of the law, judges have only one solution, and that is rely on jurisprudence. Okay, so when you find there is any particular loophole in the law, the judges can see that what kind of loophole that they have, and then accordingly, by applying the jurisprudential aspect, the legal philosophy, they come up with these particular loopholes. Okay, so they feel that particular gaps, they feel the ambiguities. Okay, because this is the basic nature of the language. Okay, so for example, if I utter any particular statement, okay, if you read any statement in the text of the law book, then you will come to know that the statement is having the plain meaning, but when you apply it to the set of facts, probably that may have the ambiguities that may arise after that. Okay, so this is the reason which is important. Then we know that theory improves the practice. Okay, so if you understand the theory, then only know that theory is going to improve your practice, your understanding, and then accordingly the arguments when you are when you are practicing the law. The present social needs, because we know that is a technological development every day that we have. Okay, and so we have to mold our principles or the legal framework, and that can happen when we understand the interpretation, when we understand the intention behind the legislation, when we understand what the theories that supports to this particular contention that I am proposing. So this is how the present social needs are important, and that can be understood with the help of jurisprudence. Then basically, to have a strong legal institution which is more comprehensible, more understandable, okay, for this reason we need to have understanding of the jurisprudence. Okay, so basically the fundamental principle of the rights and the duties. Okay, so when I say if you understand the rights, then you probably come to know that how the moral rights been converted to the legal rights, or how the moral duties can be converted to the legal duties. So according to the situation, according to the social needs, you are going to have such kind of understandable and comprehensible things in context with your legal institution that will ultimately going to make the strongest legal institution. Okay, so simple example, if your parents are saying something, okay, so it is your duty, it is your moral duty, okay, to listen to what they're saying. Okay, but it is a moral duty, it is not binding. Okay, so you can withdraw by listening to your parents. Okay, so you may just ignore what they're saying. Okay, but when it goes to some maximum extent, then court has to convert that particular moral duty into the legal duty. And so that's why you must have seen that if there is a parents, the recently the judgment I have come across given by the court, that the court wanted to so there was a fight between the mother-in-law and that lady, and the court has asked them to install the CCTVs in your areas, like in hall or in kitchen. Okay, so when you have such kind of things, okay, so it is here how the court is having or changing the approach so that we can have a legal institution which is strong and more understandable. Then we have the study of the evolution. Okay, because see, unless we understand the history, unless we understand the changes, how it has been happened regarding that particular provision, we probably would not come to know that how we have to have its application. Okay, so the evolution is important. Okay, so for example, when it comes to abolition of untouchability, okay, we have to study that how this system came and how the different kind of approaches that been developed during the history, and then how we have come up with a new approach, and then how we have deleted even the words because the words itself, they are creating the discrimination. And so this is how, when you study the evolution, and how you study evolution, by understanding the historical school of jurisprudence, by understanding the historical approach of the jurisprudence, the legal theory of the jurisprudence. Okay, so this is one of the reasons that is important. Then you have the 16th element, which is a shape and mold law for the future. Okay, make more practical laws. We cannot have only the theories. Okay, and so that's why to understand the theories is important to, so that we can mold the law according to the future generation, according to the future needs. More practicality that we can incorporate in making of the law. Then element of the reason that we have studied already, that it gives the reason for making the law, as well as for providing any particular justice in that particular concern. Okay. Just the last element that is left is regarding the grammar of law. Okay, so what is the grammar of law? It is something where we have to read the text carefully, including the punctuation marks, including the conjunction, disjunction, or, and, if, whether, henceforth, subjected to. Okay, notwithstanding anything. So when you read these words, probably you will understand that particular law in a thorough manner. Okay, in detail. And so that's why this is something we can inculcate such kind of tactics or tricks by understanding the concept of the jurisprudence. Okay. Now let us move to the next, that is the complex to simple. Okay. Now before that, I must ask you some of the questions. Okay. So what are your rights? Okay. So if I ask you these questions, it means that you need to understand the concept of right. If I say whether your right is a constitutional right, or a fundamental right, or a human right, or just a right, so you need to understand this. And unless you understand this, you cannot answer me this particular question. Okay. Or if I ask you what type of right the property right is. Okay. So right to property, what kind of right it is? Is it a fundamental right, or a constitutional right, or a human right, or just a right? Okay. So to understand this, we need to understand the concept of property as well as the concept of right. We also have to understand what is the difference between fundamental right and the constitutional right. Then probably in Indian context, we need to understand that why the property right has shifted from the fundamental right to the constitutional right. So to get the answers to these questions, I mean, these are the simple questions prima facie we can see. But when you exactly go to answer such kind of questions, then you need to understand it on a theoretical based manner. Okay, you need to understand what the property is, why we say that the property belongs to the state. Okay, why we say that we may not have the ownership over the property because we cannot destroy the immovable property. So see, there are different contexts, okay, and that we need to understand, because you need to understand this because you need to have an application of either Transfer of Property Act or the Sale of Goods Act. Okay, so see, this is how the jurisprudence helps you. Is it right of ownership or ownership of right? Okay, so I mean, see, this is just two important elements from the concept of ownership. Okay, that you might have learned. So what is exactly the difference between these two? How we can get the answer? By understanding the philosophy, by understanding what is ownership, and by understanding what is right, and by understanding right of ownership is there or ownership of right is there. Okay, so this is how we go ahead. Then I can give an example of democracy. Okay, it's also a legal concept, the democracy. Okay, if you understand, or politico-legal concept we can say, when you understand the democracy, Democracy means that particular thing where no, you have taken into consideration the view of the people at large. Okay, but still, if we say so, the rulers or the king, if they are there as a head of the state, head of the nation, still they state that their system is a democratic system. Why it is so? Because we have to find it out. What do you mean by democracy? We have to find it out why the king is saying so. Are they going to really have the democracy, or are they really going to, are they really following the democracy or not? This is to be discussed when you understand this concept. Again, the difference between a law or the law. Okay, so now we usually say in our day-to-day life, okay, I have a law. Now I have to discuss about a law. I have to discuss about the law. Okay, so is there any difference between a law and the law? And so that's why it refers to the grammar of law. Jurisprudence is the grammar of law. And the last thing, okay, know your judge. Or you must have heard this particular sentence lots of time. Okay, know your judge. What is to know your judge? Is no. First, you have to study who is judge. Okay, no, you have to study the realism. It is said that okay. I recently have discussed one of the experience that I have had in the court of law. Literally, some of the lawyers, they really wait to get the charge of the court to be changed when it comes to the bail matters. Okay, bail to be granted or not. Okay, why? Because no, you understand the judge. Okay, some judges are of the nature that they are very reluctant in giving the bail, but some judges are no are not much reluctant. Okay, if they think that okay, so it is reasonable, then they usually grant the bail. Okay, accordingly, now see, when you know your judge, you can have its impact on your final judgment. So how you come to know, how to know the judge? It is by understanding the realism. It is by understanding what the Carl Levelin said, what the Jerome Frank said, or what the Jerome Frank discussed about the about the different kind of things, skepticism about about the stimuli of a judge and the personality of the judge and how it is going to have its impact. Okay, it must, no, you must have heard that no generally it happens. Okay, so you can, when you go to the practice, it happens that generally people start understanding the judgments passed by that particular bench, and then accordingly they modify their arguments. So this is also a practice. Okay, because you come to know that how the judges are giving the reasoning, and then you can predict that in what context I can make an argument so that I can have a judgment in my favor. So this is a realism. If you read realism thoroughly, then you will you come to know that how you can build yourself as a judge, as a lawyer, or as any profession that you probably are going to have in your future. You have to train yourself to be very ready, because this is now the post-pandemic situation. Your marks are not much important henceforth. Okay, so how the skills that you have and what are the things that you have are more important henceforth. Okay, now let us go quickly from complex to simple. Okay, so what is complex to simple? Now I have bifurcated into 4 points. Okay, so what are these 4 points? The first point is that value. Okay, so the value of jurisprudence to you as a law student and a law graduate. Okay, so it is not just that from an a profession point of view you have to study that jurisprudence. Okay, you have to study the jurisprudence. You have to find out the value of the jurisprudence. Okay, so when you're a law student, or when you complete your law, you're a law graduate. Okay, you must have an understanding of different aspects that I have said, like for example, right. Okay, so you must be at point when you can bifurcate different kind of right. You must know in what type of right the discretion of the court plays an important role, in what type of right the legislatives play an important role, either in lawmaking or in judgment to be given by the judicial authorities. The second thing is approach. Approach is an introductory analysis designed to help you in your approach towards jurisprudential material, so that you may, for example, be better able to recognize funny material when you bump into it. Okay. So for example, when I say mortgage, okay, so there is a search report which has to be produced regarding such kind of things. Okay, so you must have studied the search report in context with the bank. Okay, so bank, they want search report, and the lawyer is the responsibility of the lawyer to give that search report regarding the property. Okay, now regarding the title deeds, regarding what kind of the property it is, regarding the historical background of the property, whether the person is really having a title or not. What do you mean by title? Okay, what the things are attached to the title. So all these things that you need to understand. Okay, so this is how it helps you in having the approach. Okay, and you will probably come to know that what things are wrong and what things are right. Funny is that thing which is a false. Okay, false things. Okay, so which material is right and which material is wrong. Now this analysis you can have when you understand the fundamental principles. Okay, this is the significance of the jurisprudence. Then the third is the example from existing jurisprudential point. Okay, so what is example from existing jurisprudential literature is to illustrate the approach of the jurisprudence. Okay, consider the surrogacy, the theory of surrogacy, or the rights associated with the technological development in the surrogacy. Okay, surrogate mother. You know that the three elements, their rights are overlapping over each other. Surrogate mother, the parents of the child, and the child he himself. Okay, so when you have the overlapping of the interest, then you have to make such kind of law which will resolve that dispute, or which will have such kind of law which will have a better solution to such kind of overlapping. And so here we can have an application of Roscoe Pound's theory of social engineering, where we have to check the different type of interest, and then we have to make less friction between the interest, and accordingly we have to make the law. This is how we can go ahead with the fundamental nature of the jurisprudence. And then the last one is the problem solving. Okay, what is the problem solving? It is an indication of the relevance of certain existing material to the study of the broad problems involved in the jurisprudence. Okay, so whatever may be the problem you have come across, okay, you are going to definitely find out the answer when you study the jurisprudence. Okay, when you study the fundamental principles of the jurisprudence. Then you have the philosophic exercises are jurisprudence of the jurisprudence are practical in nature. Okay, because you have its application actually in the practicality. So that's why I have written that will jurisprudence help you in the science and the art of being a lawyer? Yes, the answer is definitely yes. And so, for example, if it is a criminal law, so as the theory of the punishment or the treatment of insanity are better understood when the bearing of the philosophical issue of free will and determinism is made clear. And who is going to make it clear? Is the study of the jurisprudence. It is the fundamentals of the jurisprudence. Okay. Or for example, if you talk about the constitutional law, okay, so some other fields, many judicial opinions may come up. So particularly of an earlier era are not fully understood without the appreciation of the natural philosophy. And you have the best example of the interpretation of Article 21. Okay, or you have the best example of due process and procedure established by law. So all these things are fundamental in nature, can be understood with the help of the jurisprudence. So basic legal concepts utilized over and over again, but more or less taken for granted in those courses are intensively analyzed in the jurisprudence course. Okay, the simple example, as the Kyle ma'am has said, that we said transfer of property act in a contract. No, we utter the same words again and again: property, property, property. In contract law, breach, contract, agreement, okay, consent. So all those things in a property, movable, immovable, mortgage, lease, ownership, title of the property, all that we re-utter the words, and when we do so, it means that we least bother about the definition part of it, and we most bother about what is the provision, which shall not be there, okay, which shall not be our approach. And so a training in word analysis is is been done with the help of the jurisprudence. Okay, so problem of winning a case for a client may vary depending upon the particular jurisprudential assumptions you make. Okay, so like for example, why we say that the arguments made by the senior lawyer may have some different impact as compared to the junior lawyer. So we have to find it out. Okay, we have to find it out how know how to win the case. Okay, and how we can build up ourselves, our argument in such a manner that we can have we can more attain towards winning of the cases regarding the clients. Okay, or if you have been made vividly aware that the things in addition to legal rules, they influence the judicial decision, this should lead you to pay attention to the techniques of presentation and the persuasion. Okay, the example is the skillful shaping of the statement of facts. Okay, or you can say that a studying of the personality or the past decisions of that particular judge that I have discussed a prior in a prior slides. So that is going to give you the reasoning capacity, and that probably help you in this particular concern. Okay, so presenting a non-legalistic considerations that are usually regarded as the domain of policy. Okay, and so apart from being a lawyer, as the utility in a political officer. So if you are a political officer, if you are a public administrator, if you are a teacher, no, when you study the jurisprudence, you build up a different aspect of it. When I say religion, in the eyes of law, religion may be a divisive factor, or religion may create an obstacle in application of law. But when I understand the religion in different perspectives, in jurisprudential perspective, in considering religion as a source of law, then probably my understanding, my approach, the thinking capacity may be different as compared to the rest of the people. Okay, so this is what that we have to do. Holmes, one of the jurists, he said that it is through this that you not only become a great master in your calling, but connect your subject with the universe and catch an echo of the infinite, a glimpse of its unfathomable process, a hint of universal law. So basically, what he wanted to say, consider if you know jurisprudence, you know all the law in the world. But if you know Indian Contract Act, you only know the Indian law. Simple. When you read the Indian Contract Act, yes, the principles been converted to the law. But when you read the jurisprudence, it gives you the base of law which is applicable universally. So it is when after you study the jurisprudence, it is not going to make you just the great master of the calling, but it is also going to connect your subject with the whole universe. It is going to catch an echo of an infinite and the glimpses of the process with the universal law. Some more we can consider in a minute. Truth, control, argue, and definition of definition. Okay, so we know after understanding the jurisprudence and the fundamental base, we will probably come up with this approach. What is the public truth and what is the private truth? So one thing may be true for the public, but for me it may not be the true. Okay, or vice versa as well. Okay, so for example, consider the duties of the professor. Okay, so what it comes to the public truth, like no, I've heard that okay, so it is a pandemic situation, and why the professors have been why the college fees have to be collected and rest of the things. Okay, so this is a public truth. But as a professor, I have my private truth, because we have seen that how the professors are working day to day. Okay, even how they have worked in prior to this particular pandemic is just the college hours. But when it comes to the pandemic, no, at night they have to work, at evening, morning, afternoon, every time of the whole day they have to work. So this is a private truth. So when you understand the theory, then you will probably come to the type of truth. Okay, control. So you come to know that how the things been controlled by human control and non-human world. Okay, So that's why we come to conclusion that animals, do they have rights? Do they have human rights? No. Animals don't have the human rights. Animals have the rights. But that rights are those rights where they are not attached with the duty. The duty lies with the protector. The duty lies with the owner of that particular animal. The duty lies with the state if the state is protecting any particular wildlife sanctuary. So this is how we come to know, conclusion of different aspects. Argue. So knowing whether to argue is as important as knowing what to argue. Okay, the most important when it comes to the lawyer's perspective. Okay, you must know. Oh, no, knowing whether to argue is important instead of what to argue. Okay, so the content, apart from the content, you have to know that the reason behind this particular thing. Okay, the content of the plaint is there, but you must know the reason that why you have put forth this into the plaint before the court of law, and the definition of definition. Okay, so it is the content also matters. Okay, so when you have any particular definition, you need to understand the definition of the word definition. When I say define right, what do you mean by definition of that particular right? Okay, so you are going to define the right, it is good. Okay, but what you include when you define any particular thing? So this is a kind of a complicated system. At a prima facie level you may think, but when you try to build up your approach, your reading, because how to study the jurisprudence is also important, right? And so you have to build that approach in understanding the jurisprudence. Okay, so what's the use of studying the schools, the concepts, the sources? It is that what we have discussed so far. Okay, so we know that there are theories like sociological, natural, positivist theory, historical theory, realism as well. Okay, now let us try to understand one example. Okay, you must have heard probably there is a debate of Hart and Fuller. Hart, actually Hart, Fuller, he's a jurist. Okay, so in 1958, H.L.A. Hart posed a hypothetical. Okay, so I have given a reference from where I have taken this particular element, this particular part of Hart and Fuller debate. Okay, I'll just okay, you can just read it out. I'll just explain it in a simple way. Okay, consider that there is a park. Okay, a public park, and outside the park there was a particular notice which has been there, and the notice says that the vehicles are forbidden. Okay, so you shall not park your vehicles. Okay, the entry of vehicle is forbidden by the park. Okay, now what was the debate regarding this issue? The debate was that what do you mean by vehicle? Whether the vehicle means automobile, whether the vehicle means bicycle, because see, bicycles can also be there in the park to have a round around the park. Whether roller skates are also been considered as a vehicle or not. Toy automobile, so like for example, if I've come up with the child in the park, so whether his toy automobile shall be considered as a vehicle or not. So to what type of vehicles this particular notice is applicable. Okay, and so this is how we have to find out the purpose of the rule. Okay, and how we have to find out the purpose of the rule. Now consider that there is an area of illegality, that is the park. Okay, so it means that all the vehicles are banned from coming inside the park, but there are exceptions. So exception is that the police vehicle, because police, if they want to perform any particular duty, they can come up. If they find that the culprit is hiding behind the bush in that particular park, then police can come. So it is an exception for the police vehicle. So that's why you can see there's there is a gap in the area of legality, because it is an exception. But again, there is an exception to an exception, because police vehicles can come. Okay, they can be there in the park, but we need to understand for what purpose. So if the police officer is coming just to have a round as a morning walk in the park, now he cannot come, he cannot park that particular vehicle, that police vehicle, into the park. Why? Because it is the area of illegality is there. You have exception to it, and then again you have exception to exception. Okay, and this is a kind of complex to simple. Okay, so that's why like we can have a simple example. Okay, if you take a Google map, you can see the Indian the map of India in the Google map. Okay, if you see Mumbai, so it is just a plain line. Okay, if you zoom it, then you can see it in the left side image. Okay, it's some peninsula in the in the sea. And if you zoom again, then you can see that it is not the straight line which we have seen, but it is a kind of an rough thing. Okay, so it is not a straight we can say land which is belonging to that Mumbai. Same happens with Rameshwaram. Okay, so peninsula with that particular part. Okay, in the sea. Okay, so you can just see some part when you have the overview, but when you analyze it in depth, then you probably come to the conclusion. Okay, now as it's 12:03, I think I'm having a little bit time. Okay, but to its conclusion, I must show you some of the memes that I have created and posted. Okay, it is just not that no, you have to be no very serious about the jurisprudence. Okay, it is not a serious subject. Okay, so when you create some fun, when you no, because see, okay, you studied your history paper. Okay, and there are a lot of things that in the history paper that you shall have to remember. Or for example, people from the science background. Okay, like you have the periodical table, and to know each and every element of the periodical table, you might have come up with some tricks like kakas kati bakromani fekoni kudunagagi asise barkar. So if I write this line, it gives the whole line of all the elements, the longest line of the periodic table. So you must have done that particular thing. The simple thing, you can correlate it with the day-to-day things, okay, to memorize it. Okay, so it is just not creating a fun of law. It is something how with fun you have to learn the law. The same example, okay, I have posted John Austin's statement. Okay, no, so these are the statements. Law is the command of sovereign. Now read the analytical school of jurisprudence. Okay, Rajamata Shivagami, Bahubali, Mera Vachan hi hai Mera Shasan. Okay, so whatever I am saying, it will be followed. So what is this? This is nothing but the John Austin statement. Law is the command of the sovereign, right? Or coming down to a Bollywood movie where the judge said that "Kanun andha hota hai, judge nahi." Okay, what it means that law can be considered as blind, but judge is not blind. Now read out it in context with the realist school of jurisprudence. I'm just reading out the statement. Realists don't give any importance to the laws enacted by the legislature, and they uphold only judge-made law as a genuine law. Why? Because see, the law can be the dead letters of the text. Okay, so the letters of the law are dead, but the judges are going to put a life into those dead letters. Or for example, you must have seen these movies as well. Okay, now I'll read out the Eugen Ehrlich statement in the sociological school of jurisprudence. At the present, as well as at any their time, the center of gravity of legal development lies not in legislation, nor even in a judicial decision or juristic decision, but in a society itself. Now here, sociological jurisprudence, they are they're not believing in the positivist approach, or we can say the realist school of jurisprudence. They have their different approach, the societal approach. And so if you can read like मैं कानून का बाजू नहीं का खुद कानून बनूंगा, और ऐसा कानून जो खुद मुजरिमों को पकड़ेगा, खुद मुकदमा सुनेगा और उसका फैसला भी खुद करेगा. See, okay, correlation you can analyze with this particular statement. Even it happens that in a jurisprudence class, okay, when you teach H.L.A. we can see H.L.A. is the person who you will find in a sociological, who you find in a real, who you find in a natural school. Okay, a number of things that you find with the H.L.A. teaching, and you always keep uttering legal positivism, external aspect, internal aspect, primary rules, secondary rules, rules of recognition. So if you read the rules of international law, has stopped. Okay, And so so that's why the ultimate aim of a jurist, okay, is to give you an understanding of the principles. Okay. Now again, you may have one more question, like why we have to study different kind of jurists. It is not important to important to understand the theory given by each and every jurist. Okay, it is their point of view. Okay, it is not your point of view, right? And so whatever that you read, you may follow, you may not follow, but this is their point of view. Or they may have given that particular theory considering the history at the backdrop. Okay, so probably if you try to understand the Saint Thomas Aquinas, who has given a different kind of approaches of legal theory. Okay, so lex eterna, lex humana, lex divina. Okay, lex naturalis. So what is this? You know that at the backdrop there was a kind of Christianity which was developing the principles, the Pope and his interpretation of the law was there, and so that's why he comes with this particular theory. So it may happen. So you don't have to take into consideration that no, you are lagging behind in understanding the theory. Okay? Same happens with the Scandinavian realism. Okay, so you know you probably will have the jurists Axel Hagerstrom, Karl Olivona, Alf Ross, Andrew Willem Luntert. So though the names are difficult because there's a Scandinavian realist scholar, but still, as I say, it is not always that no, you have to keep your eyes on this. Okay, whatever that they have said, you can just have to understand and analyze. Okay, so this is how okay, we can correlate with the Indian Contract Act as well. Okay, section 25, if you read with section 2D, an agreement made without consideration is void. So you need to have the agreement with consideration. Okay, so बिकते तो सभी है, कुछ पैसों के लिए, कुछ जज्बात के लिए. Okay, so this is how any type of consideration, the consideration shall be there. Okay, and so you can correlate this Indian Contract Act and this particular consideration with the rest of the enactments. You can find it with the Transfer of Property Act, with the Sale of Goods Act, with the land laws. Everywhere you can find the protection of this particular consideration in different contexts when you study the jurisprudence. Okay? So this is so far about the fundamentals and the significance of the jurisprudence. Okay, so you can very much contact me with my Yahoo mail address. I have posted. You can WhatsApp me on my number I have given in the slide, and also you can go to sourabh.weebly.com, and you can have an access to some research material and the blogs as well. Okay, so I can say I raise my argument in convincing you regarding the jurisprudential understanding and the jurisprudence, and I guess have an idea regarding this particular aspect, why we have to study the jurisprudence, and what we have to study in the jurisprudence, what are the fundamentals of the jurisprudence, and then we have to consider the different angles how we can have its use in the practicality. Okay, so if you have students have any doubt, you can post it in the chat window. I'll just read it and I'll try to give the answers to it.
Yes, sir. Mr. Prem Mishra has posted a question, sir.
Okay. Okay. Can you give any Indian definition of the jurisprudence? The best part, thank you, Prem Mishra ji. Why? Because see, when we read the jurisprudence as a subject of the law, we least bother about the Indian jurist. Okay, so when we talk about the Indian jurist, no, we can start it from the Kautilya's Arthashastra. Kautilya has defined the jurisprudence in better manner. Okay, and the Kautilya, I mean, see, 300 before Christ is the period Okay, so when we have the 300 before Christ period, we had a positive law, we had the written law. Okay, and so they have said that whatever the rules that they have made in that particular Arthashastra shall be followed by the individuals. Okay, so I can say that jurisprudence from that part is something where it gives a positivist approach. Okay, because see, when you define the jurisprudence in the jurisprudence paper, you define it with the help of different schools, different theories. Similarly, we have it in an Indian context. For example, if we talk about the Amartya Sen, it is some different context. Okay, or take an example. Okay, Justice Bhagwati. So it is more concerned towards the realism, okay, judicial activism. So through that angle, through the realist approach, we can have this particular definition of jurisprudence. Okay, so basically jurisprudence as in general mean in Indian context is understanding the Indian perspective of each and every word which comes as a part and parcel of the legal provision. Okay, so this is how we can consider the Indian perspective. Got the second question: what is the difference between the rules and the principles? Okay, for example, if I say that principle of estoppel, if I say that you shall not go against what you have already agreed, so this is a principle. But when you convert that particular principle into the contractual law in the provision, then it is a rule. Okay, so why we consider it as a rule? Because it is something where it is that rule that you have to follow. Okay, and so this is through example we can say that the principle, or for example, you can see a number of principles in the law of tort, but when you utilize those principles, when the in a realism, when the court gives the judgment, it means that at the time when the court gives the judgment, it becomes a rule. Okay, prior to the rule, it is a principle. Okay, or for example, like ceremonies in the mentioned in the Hindu Marriage Act. Okay, so it is a kind of a principle, and when we have converted to the Section 7 of Hindu Marriage Act and the seventh step, then it is being converted to the rule. Okay, so this is probably a phase wise we can consider the rules and principles. Okay, thank you so much, Shaktivel sir. I'll just take a question, the last question probably. What is the responsibility of judges when their personal opinions are in conflict with the rule of law in the case before them? How the jurisprudence or a jurist views it? Okay, so that's why I say that the responsibility of the judge is also one of the element which makes its impact on the final judgment. If you read out on the legal realism, you will find it out that it is Jerome Frank. He said that the courtrooms shall be considered as a laboratory and not the library. Okay, so ultimately, when it comes to the courtroom, it is something how we are going to treat it, the state of fact. Okay, general to particular to general. Consider, for example, okay, I'll give an example, okay, how the personal opinions they have an impact. Okay, if some kind of religious matters are there in the court of law, probably you may find that the constitution of the bench is of such nature that they try to appoint the judges of different religion so that we can have a different approach. Okay, particularly we can also say that of the case where the entry of girls of that particular age been restricted by the temple authority. Okay, but when you try to read out that particular judgment, then you come to know the one of the point in the judgment given by the judge is contrary to probably contrary to what probably have been uttered as a final judgment. Okay, try to read out that judgment. Will probably come to know that how this happens, that their personal opinions may have its impact. Now, still, Now see, judiciary is the only thing in the whole world, wherever you go, that we believe the truthness, or we believe more in judiciary than the legislative. Why? Because this is the structure that they have maintained regarding the belief of the people in their system. Okay, so that's why there's a higher responsibility is also there on the judges. So a jurist, depending upon which school he is belonging, he differs with the judgment. Okay, so I hope I have given the answer. Okay, I think that are these much questions. Okay, so hope you have enjoyed the lecture as well. So now I raise everything here, and I give all the very best for your future endeavors. Wherever you go, as a faculty, will always be there. Not only the Kyle ma'am, but we also the faculties which are associated with the Government Law College Villupuram will be there for you to help you in any matter related to academics and your career. Thank you everyone for patient listening, and special thanks to all the faculties,
Thank you, sir.
students,
Before moving to
the
vote of
volunteers.
thanks,
Yes.
Before moving to vote of thanks, may I invite our principal ma'am for your comments. Over to you, ma'am.
Yes.
Principal ma'am. Okay, then may I invite Miss G. Kirtana, LLM, to propose vote of thanks. Over to you, Miss G. Kirtana.
Thank you, Jennifer. A very good afternoon to one and all present in this 16th special lecture, Revisiting the Fundamentals of Jurisprudence and its Significance, organized by our esteemed Government Law College, Villupuram. Gratitude is not only the greatest of virtues, but the parent of all the others. It gives me immense pleasure to deliver the vote of thanks for this event to all the dignitaries assembled here. I would like to thank our special lecturer, Sri Sourabh Vasant Chhaya Ubale, Assistant Professor of Law, Marathwada Mitra Mandal's Shankarrao Chavan, Law College, Pune, who honored the 16th special lecture in this academic year with his inspirational thoughts and extraordinary knowledge. I would like to thank our beloved principal, Ma'am Dr. N. Kayalvili Ma'am, for a tremendous effort in conducting this special lecture. I thank all the staff members, law students, participants, volunteers, and last but not the least, our beloved advocates for making this special lecture a grand success. Jai Hind.
Thank you, Ms. Kirtana. It seems Principal Ma'am has facing some technical glitches. Thank you, sir. Thank you once again for your wonderful explanation with the visually, medially. I mean, you have covered everything along with the jurisprudence as well as the media. Thank you, sir. It seems we have all the students have enjoyed a lot from your lecture. Thank you very much. Have a great career, sir.
Yes. Thank you, everyone. Have a great day ahead.
Thank you, sir.